Before your eyes glaze over and you think this law, this CTA law, doesn't apply to you, you're wrong. This law applies to millions of businesses, particularly small businesses. So if this law doesn't apply to you, it probably applies to someone you know or lots of someones you know. Hey everyone, it's ISE&x. Thanks so much for joining. Today I want to share with you a particular judge's written opinion. Now, in case you didn't know, a written opinion from a judge becomes case law precedent. So when attorneys go to court to try to help their clients win in the courtroom, we're going to be looking at one of two things. We're going to be looking at a statute, which is like a written law that comes from like a legislature where they write down code, rules, law, or we also have case law precedent. And what that means is there have been previous cases where a judge has made certain rulings and then that becomes binding on future judges. So that's case law precedent. Usually judges' written opinions are like really dry. They're not entertaining. They're boring. You wouldn't want to read it. The only time it's interesting, even to lawyers, is if it happens to match the facts of your case so that you can say, hey, judge, hey, jury, this is like this other case, and you're bound to rule in my client's favor because my case is just like that previous case where the judge would have ruled in my favor, right? So usually these opinions are like not exciting, but this one is exciting. So this is National Small Business United versus Yellen, and this is the case that rules on constitutionality of the Corporate Transparency Act, or CTA. And this case will probably be appealed to higher level courts, probably all the way up to the US Supreme Court. But for now, this is kind of like just getting started, and this is the district court judge's written opinion. Typically not that exciting. This one is actually really well written. I enjoyed reading this one a lot. So to begin, the judge just starts with sort of what is the CTA and this requirement of something called the Beneficial Owner Information Report. Now, don't let your eyes get glazed over. You're thinking, well, that doesn't apply to me. This is stupid. No. It totally applies to you because this law, this CTA and this BOIR requirement hits like millions of businesses in America, like many, many millions. And so if this law doesn't apply to you, it probably applies to a lot of people that you know. So it's like this huge big deal. And so in this particular case, the judge says, when Congress passed the 2021 National Defense Authorization Act, a bill called the Corporate Transparency Act, before your eyes glaze over and you think this law, this CTA law, doesn't apply to you, you're wrong. This law applies to millions of businesses, particularly small businesses. So if this law doesn't apply to you, it probably applies to someone you know or lots of someones you know. The judge actually does a pretty good job explaining how the CTA came to be and who it applies to. So the judge writes, when Congress passed the 2021 National Defense Authorization Act, that law included a bill called the Corporate Transparency Act. Although the CTA made up just over 21 pages of the overall law's 1,500 pages total, the law packs a significant regulatory punch, requiring most entities incorporated under state law to disclose personal stakeholder information to the Treasury Department's criminal enforcement arm. Already, I think this judge is hilarious because he's pointing out that Congress passed a 1,500-page bill that's for defense, national defense, and in it is buried 21 pages that will affect millions of Americans. And he's already pointing out how ridiculous that is, but let me keep going here. By requiring these disclosures, Congress aimed to prevent financial crimes like money laundering and tax evasion, which are often committed through shell corporations. Broadly defined, a shell corporation is a legal entity with no or minimal employees, customers, business, or assets. Although shell corporations serve many legitimate purposes, it's also possible to disguise the identity of interested individuals and the flow of money, layering shell companies on top of each other. So now he's saying, okay, you buried this 21-page law in 1,500 pages in a defense law that applies to all of these small businesses. But at least let me tell you what the aim of that law is, which is a good thing. We don't want money laundering or tax evasion. So the judge is saying, okay, here's the purpose of this law. But now the judge is going to start poking some holes in the CTA and its noble aims. The judge writes, yet corporate formation includes far more than for-profit enterprise. Each year, the states grant formal status to millions of entities that can and do serve any lawful purpose, including benefit corporations, nonprofits, holding companies, political organizations, and everything in between. And with that in mind, the judge says this case presents a deceptively simple question. Does the Constitution give Congress the power to regulate those millions of entities and their stakeholders the moment they obtain a formal corporate status from a state? That's the question. So the constitutionality rests on, is the answer to that question yes or no? And I'm going to repeat it. Does the Constitution give Congress the power to regulate those millions of entities and their stakeholders the moment they obtain a formal corporate status from a state? Let me put the written opinion aside for just a moment, and I want to talk to you about how in the real world the CTA has applied to me and so many of my clients. Okay, the CTA requires that all of these companies or these entities file with FINCEN, which is this federal program, this federal arm that is designed to investigate financial crimes, and it goes by the acronym FINCEN. FINCEN set up this website where people can go, all these small business owners can go and file their personal information. Now, FINCEN promises, we're going to keep this confidential. We're not going to share this information with anyone. Well, a lot of my colleagues go, well, sure, it's totally confidential until the IRS comes knocking or until you get hacked. Until then, yeah, it's totally confidential. And so a lot of people are up in arms with this beneficial owner information report where you have to go online, all these small businesses and trusts and all kinds of stuff, you have to go online and divulge all of your personal information to this FinCEN thing with the promise that they'll keep this confidential information confidential. There's all kinds of vague issues with the law itself. I mean, as you saw, this was just 21 pages buried in a 1,500-page defense bill. And so you have all kinds of vague stuff. Like, for example, it says that entities must file. Well, what exactly is an entity? Well, we don't know exactly, not with any clarity. And FINCEN just says, well, use your discretion. If you think you might be an entity, then you probably should file. Well, what's the problem with that? How do I know if it applies to me or not for sure? And you're threatening me with fines and jail time if I don't comply with these vague descriptions. And it seems really unfair, remarkably unfair. It seems like a bit of an overreach to a lot of people, so people are rightly up in arms. But like I said, this particular written opinion is really, really good. And let me continue. The judge says the CTA exempts 24 kinds of entities from its reporting requirements, including banks, insurance companies, and entities with more than 20 employees, $5 million in gross revenue, and a physical office in the United States. So again, this was only designed to hit and apply to small businesses. I guess the thought being that small businesses are more likely to be shell companies or somehow involved in money laundering. So big companies with more than 20 employees, they're exempt. They don't have to give their personal information. Only the little guys have to give their personal information. The judge continues. In total, FINCEN estimates that the CTA applies to 32.6 million currently existing entities and 5 million new entities formed each year from 2025 through 2034. The judge goes on, the CTA requires these millions of entities to disclose the identity and information of any quote-unquote beneficial owner. And then he goes on to define, really vaguely define, what a beneficial owner is, including any person who exercises quote-unquote substantial control. So like I just said a minute ago, who this law even applies to is vague, which is hugely problematic given that they can put you in jail and fine you like $500 a day if they determine you haven't complied and the law does apply to you. So even though it's not really clear who the law even applies to, what is a beneficial owner, who has substantial control, what does that even mean without any body of law or real concrete definition, they can fine you up to $500 a day or put you in jail. It was, like I said, only a matter of time before the constitutionality of this was contested. I am not a lawmaker, and I'm not going to tell you whether or not I think personally this law is a good idea or a terrible idea. You might be able to already tell from the way I'm talking about it. But I do want to say that constitutionally, or the constitutionality of this is actually really, really interesting. What laws can Congress really make? Where does the United States citizens' rights begin and end? Can they even do this law without breaking your constitutional rights? That's what this case is about. It's not about whether or not the law is a good idea. That's not what's at issue. It's not about whether it's stupid. It's about whether or not it is constitutional. And it's, like I said, this opinion is really well written. You should read this opinion. And again, this is National Small Business United versus Yellen. Now, I have to read you the intro to the judge's written opinion because I just think it is one of the most hilarious and eloquent openings that I've ever read. So listen to this. The judge writes, to begin, the late Justice Antonin Scalia once remarked that federal judges should have a rubber stamp that says stupid but constitutional. The Constitution, in other words, does not allow judges to strike down a law merely because it is burdensome, foolish, or offensive. Yet the inverse is also true. The wisdom of a policy is no guarantee of its constitutionality. Indeed, even in the pursuit of sensible and praiseworthy ends, Congress sometimes enacts smart laws that violate the Constitution. This case, which concerns the constitutionality of the Corporate Transparency Act, illustrates that principle. At the end of the day, this law applies to millions of people. If it doesn't apply to you, I promise you it applies to someone you know. Over 32.6 million entities, which even that is broadly and vaguely hardly defined. All of those entities are having to give up all of this information about beneficial owners. These small businesses, these small American businesses, are having to divulge sensitive personal information to this organization, this federal government organization called FINCEN. And is that constitutional? Do they have to give up that information simply because they filed to create an LLC? The moment they created an LLC, do they automatically have to divulge the sensitive information to the federal government? Well, this written opinion from this judge digs into that. And not only is it really interesting constitutionally, this article, or rather this judgment, is really well written.